Matter of BISBING versus BISBING. May we please have appearances of counsel?
Good afternoon, Your Honor. May it please the Court, Paul Townsend, POWN, from the law firm Townsend, Mayo, Matthew Nunn and Bonnie Ross from Michael Harris on behalf of the respondent. Timothy McGoffin on behalf of Amicus, New Jersey State Bar Association.
Good afternoon, counsel, and welcome. Mr. Townsend, please go ahead.
May it please the Court, I'd like to reserve 5 minutes, if I may, for rebuttal.
We'll have you back, hopefully for a little less than that. Go ahead.
Thank you, sir. Chief Justice, Justices, what I hope happens here today is that we do not forget the two people that have been impacted the most from the appellate division decision. Gianna and Gabriella were allowed with their mother to go to Utah. They went to Utah. They finished a scholastic year in Utah. They're now back in New Jersey. I am a divorce lawyer. I do not think there's anything more complicated or difficult than that, because every minute of every hour we have to work with feelings and emotions. And every day I am reminded that we are imperfect people, all of us, in an imperfect world. However, I believe the appellate division made four main errors. One, they said Section 1.9 was a non-relocation clause. Section 1.9 is inconceivable that a non-represented parent of primary residence would ever say or sign anything that says, I will never, ever leave the state of New Jersey. Two, the appellate division created two standards heretofore unknown. Substantial unforeseen change of circumstances, and we have to disprove bad faith. That goes against the weight of the case law against precedents. Three, those two standards are overbroad, overburdensome, cannot be defined, are subjective, and are based on suspicious activities and surmise. And four, the parent of primary residence is not able to travel to relocate with their children. Bowers is good law. Since 2001, it has done what it is supposed to do. It is an objective, expeditious method for the trial court to come up with a resolution regarding relocation. It works. It should not be changed. The wheel should not be reinvented. What I believe the appellate division did was to cram a particular set of facts to reach a conclusion. And in order to reach that conclusion, they had to create those two standards. What they have done is literally open the floodgates of litigation. Every case will be tried. There will be a plenary hearing in every single matter. But they've also put the issue of fraud where it does not belong, in the sense that there is the thin thread of fraud in almost every position, in almost every case. Are we then to be ruled by that thin thread of fraud? I do not believe so. Also, the two standards create such a subjective element to that which was objective before, that every single thing is suspect, every single thing is subjective. It is impossible to know one's subjective intent or the subjective intent of third parties. And finally, what I believe my adversary is asking this court to do is to create law. Now, the legislature creates the law, and we all know the laws apply by the justices. If there is any question whatsoever, please look at RSA 1 and their arguments. They want the law changed. They want these justices, you, to change that law. I do not believe that law should be changed. I believe you should exercise original jurisdiction, let Gianna and Gabriella go with their stepbrothers, go with their stepfather where they have been, and return. Judge Wright did the correct thing. The appellate division has changed all that we have practiced since 2001. I am now happy to receive any questions you may have.
Let's start with your first point. Tell us why it seems as though you're shooting for the moon, because there is language in 1.9 that states neither party shall permanently relocate the children from the state of New Jersey without prior written consent of the other. Why shouldn't that be held to mean what it says?
It means what it says, but what would work for the appellate division in my sense when we drill down into the language of this is if it just said we'll never leave the state of New Jersey. When you have without the written consent, does that mean that consent is always no? That consent is never given? That is what the statute says. That is what is meant by this. Now, perhaps if the clause was entitled non-relocation from the state of New Jersey, you're going to be stuck here forever, I might buy that. I might agree with that. However, when you see that it matches and mirrors the statute, it makes sense.
I may have missed something. There's no dispute that the father refused consent, correct?
That is correct.
Under those circumstances, does there not need to be some resolution of this? There's no consent. The agreement requires consent to leave the jurisdiction. What's the answer to that? And can a court simply say, I've decided it's not inimical to the children's interests, or it's in the best interests? What's the answer to that? Consent was denied. What's the next step?
Since 2001, Bowers has given us that objective guidepost. What should happen? And what should happen when two people who are either when they're about to get divorced or are divorced, the judge, the trial court makes that decision.
How?
By certifications that he reviews,
They're
by
in
oral
dispute.
argument.
Okay, there's certifications, there's oral argument. There's obviously a dispute as to what is in either the child's best interest or inimical to the interest of the child, because dad says we have a very close relationship, I'm part and parcel of their lives. In fact, I'm not saying this is exactly the facts, but I've largely been part of every aspect of their life from the beginning. Are certifications enough? Should there at least not have been a plenary hearing?
You said two things, Your Honor. Oh, I didn't mean to cut you off. I'm sorry.
No, I'm done. Go ahead, correct me.
Thank you. There are two things you said together which should not be said together. Inimicable and best interest.
No, I don't know. Whatever that standard is. I know.
Those are two different standards. First, we look whether there's a good faith reason, remarriage. Then we see if it's going to harm the children. We go through the 12 factors of Bowers, which is exactly what Judge Wright did. Barblock says not every case should be a plenary hearing. That if the facts are clear enough, then the trial court can make that decision.
And your argument is that's what we have here. The facts are clear enough.
That is exactly what we've had here since 2001. But what they're trying to do
doesn't
is
the court get to
decide,
Counsel, doesn't the court get to decide whether the facts are clear to the court? Isn't the court's function to determine whether the facts are clear? And if the court's unsure, what prevents the court from having a plenary hearing to get information from the parties?
That is up to the trial judge, sir. That is what the trial judge is supposed to do if he believes the certifications don't rise to the level or do rise to the level. Exactly.
So you don't object to a plenary hearing at all? You're saying in some instances they shouldn't have a plenary hearing?
Correct.
Okay.
That is exactly what Bowers has said since 2001.
Bowers requires good faith. So even if we're just looking at good faith, it seems to me what the appellate division was doing, even with the language substantial unanticipated change, was looking to see whether or not your client acted in good faith with respect to the relocation provision to which the parties agreed. And the appellate division concluded, well, that determination certainly could not be made based upon the certifications. That's what required a plenary hearing. Am I mistaken about that?
Respectfully, yes, sir.
Okay, explain how.
If the appellate division had simply said, go back for a plenary hearing, we believe this is what it is, then I would agree with your statement. But what they did was create a new standard Substantial unforeseen change of circumstances, I don't even know what that is. How on earth were you going to have the entire state of New Jersey in every divorce case trying to define that? But they also use the term bad faith.
Okay, so forget about that language. Did your adversary have a right to a plenary hearing so that there could be a determination whether, at the time this relocation provision was agreed upon, your client already had plans to move to Utah?
No. And let me tell you why, sir.
Go ahead.
If I may. What we have to do is then we all have to put ourselves into the minds of someone's subjective intent who may or may not be in a relationship. Who knows what the
courts do that
relationship
all
is
the
going to
time.
be?
Courts evaluate contracts, the meaning of contracts, the intent of contracts. They evaluate the intent of parties all the time in civil cases and in family law. Why is that so shocking that the court would send it back, the appellate division would send it back and say, find out what was happening so that the court can make a determination of whether there was good faith or not?
I agree with Your Honor. It's a wonderful question, and I believe I'm ready for it.
Oh.
Intent.
Okay.
Go for it.
Intent in criminal matters. Did he intend to pull the trigger? Objectively, that's very easy.
No, but
you pull a trigger and it has
civil
to.
matters
Did you
all the time.
intend?
Let's bring it something close to what it is. Parties enter into contracts. This is a contract. Parties enter into contracts all the time. Courts, as a matter of routine, determine what the intent of those parties was, and they determine whether there was a bad faith in the inclusion of a provision all the time. That's not any shocking function for a court.
But it is the analysis of a provision. It is not the analysis of the subjective intent of a person or the subjective intent of a third party.
Good faith.
That's the
Good
danger,
faith.
I believe,
Good faith
with this decision.
You didn't use a good example with the criminal, because purposely and knowingly requires a determination what the person actually thought. That's not an objectively reasonable standard. Okay. So the reason.
What about driving the car 100 miles an hour down Main Street?
How do you determine good faith in this case?
Good faith is done and determined, quite frankly, Justices, by Bowers. It says, and the history says, almost any good reason that does not interfere with the defendant's ability to have a relationship is good faith.
Didn't Shea, I mean, Shea's a law division case, I get it, but it's been followed since then. Didn't that answer the question in a different way than you are? In other words, didn't Shea, once the defendant says that there was bad faith, that the mom knew exactly what she was going to do when we signed this agreement, and that's the only reason I gave up parent of primary residence, whatever the allegation is. Doesn't Shea say, once that's been done, you go back, you have a plenary hearing on whether there was good faith in the case, and then we go from there? And I think that's kind of where Justice Allen was headed. Isn't that what Shea says? And are you saying we should? It is a law division case, I understand, but should we just disregard it?
No, sir. I would draw another great question. I would draw this distinction if I could. Shea talks about bad faith, but it also deals with an objective factor. That is, whether the mom was in North Carolina before this was done. We can all tell the mom was in North Carolina. That's a yes or a no. And as such, we can then see the bad faith objectively. But what the appellate division has done is
that the only
create
factor
a
to determine bad
subjective
faith where the
area.
mother was?
Pardon me,
Is
sir?
that the only factor to determine bad faith, where the mother was, whether she was in North Carolina or not? Aren't there numerous other factors that you could consider?
I believe the distinction between Shea is just that the mother was in North Carolina, an objective standard. And that's one of the positions I need to put forth here, that Bowers has an objective standard, but the appellate division requires all of us to know the subjective intent. It's going to chill every property settlement agreement that's ever made and allow every single one to be litigated.
So, good faith typically looks to the person's personal intent, typically. That doesn't mean that objective factors might not give credence to what the person is saying. But you could look at 10 objective factors, but if we'll use this example. Despite the objective factors you want to point to, if your client, in fact, had a plan at the time of the relocation clause to move to Utah, you would concede be bad faith, despite what other objective factors you might look at. For instance, let's say she told someone, boy, I just signed this relocation agreement, but in 9 months I'm moving out. And you're pointing to 10 objective factors that indicate good faith. Are you suggesting that admission wouldn't come in to show what she was actually thinking? You understand my question?
I do. I have an answer for you,
Go
sir.
ahead.
I was making notes. We then are required, because you pick the exact situation where every single divorce case, in theory, has a neighbor coming in, a friend coming in, someone else coming in. Your objective factors, Your Honor, if I may, what are we going to do? Phone calls? Text messages? Are we going to do whether or not it was in a temporal analysis? Well, you were 2 months away, and when you decided to move, or 7 months away. Are we going to have a chart from now on?
Family
that
part judges deal all the time in evidence of what people said and intended and actually did, and also their communications with one another. This is not introducing some new concept into the function of a family part judge. How can you argue that?
Very easily. Thank you for that question.
Okay.
Here's what
I notice you're only praising the questions on this side of the room.
I'm sorry.
That's what always
Yeah.
happens. That's what always happens.
I feel confident there will be one from that side of the room.
We're
Thank
waiting.
A crazy question from this side?
you. No, a wonderful question, sir. Not a crazy question. Here's what I would say to that the system works. And when you start changing it to that subjective factor and you take that away from the judge, you open the floodgates to plenary hearings on every single one. Bowers expeditiously works.
You say over and over every single case. Now we're not dealing with something that would be routine. There are lepus hearings all the time on changed circumstances in many different kinds of cases, but this is not your garden variety situation. This is a situation where there's a particular agreement with particular terms, and then there's a relocation out of state, and there's no consent, and there's litigation over it. It's a small subset of family part cases. So in terms of the number of hearings that were, if that's your argument, I'm not sure that's really borne out by the circumstances here.
It would happen, respectfully, being a matrimonial attorney, in every single case.
Bowers sent it back for a hearing. I'm trying to get your... Bowers actually was a remand for a hearing for the production of proof. That it was a plenary hearing. That's what Justice Long was ordering. Am I mistaken?
Sir. Yes, sir. But I'm talking about...
I am mistaken?
No, you're not. I'm sorry. You're not mistaken. Bowers was a remand.
Question.
That's what I was answering. No, sir. You're not mistaken. We then put bar block on top of Bowers that allows, in certain circumstances, a judge to expeditiously resolve this case. Remember, he was not the parent of primary residence.
But he acted...
He was the every other weekend.
But he acted more in the role of a joint custodian than he did... hang on. Than he did as a I forgot what it's called, but of a...
shared parenting.
A shared parent. He was there, he went to games, he did the things that he was supposed to do as a father, and even your client, up until the end, treated him as an equal. They didn't abide by the visitation requirements. He was permitted to have them at times when he wasn't supposed to have them. They stayed with him, they stayed with her, and everybody was in close proximity. Now she moves away, and I think even on the Bowers, we're supposed to look at the effect of this on the children. And when you lose a parent because they're on the other side of the country, that's going to have an effect on the children.
I'm glad you asked that question.
I was happy to ask it.
Thank you, sir. If I would draw the court's attention to O'Connor. O'Connor answered just that question. The question was raised by a father who alleged that he was an equal parent. He was not. The court said no. We are not going to do that analysis. What we're going to do is we're going to look at what they agreed to when they entered into the agreement. When these two parties were equal, when these two parties had equal bargaining, he didn't say, I want to be the parent of primary residence. He didn't say that at all. He said, let me see these kids every other weekend and one night a week.
But that's not what happened.
That is exactly what happened.
Oh, he saw them more.
No, he didn't. He just saw them at a softball game on his weekend, or he saw them on another softball game on his weekend. Your Honor, in our world...
But they had other weekends. I mean, he had these kids on weekends when he was not under the agreement supposed to have them. And you've been arguing since you stood up on looking at the objective facts. And I think that's what we're looking at. We're looking at his role as a parent, and as a parent who was an active parent. He wasn't a no-show parent, and that's the issue here, including the issue that the social science since Bowers has changed, and the social scientists are saying that we are to look at what's in the best interest of the children here, and not only take a look at what the agreement is. And so I'm having a hard time understanding why we shouldn't be looking at the changes in social science since Justice Long's opinion in Bowers. 43 questions there, but answer any one you want.
2 reasons, sir, if I may. What we have to look at is what he requested when he had the opportunity. He didn't say he wanted to be the parent of primary residence. He said, 3 nights, every other weekend, that's what I'm going to do. Now, regarding your question about whether he was at the softball games or whether he was there, that is O'Connor. If you want to overturn O'Connor, I understand your position. However, what happens and what I want this court to understand is that he was not that involved. From the record, I believe you can say in this particular case, if you want to change the law, I understand that. But in this particular case, from the record that's in front of you, if you look at the record, he can't really point to that.
But you look
Nor
at it,
can he point to the fact that he wanted more time.
You look at incentives that exist when parties are negotiating settlement agreements to resolve marital disputes. And you have, in this case, a relocation provision that says neither parent should relocate intrastate, and then has the permanently relocate language. And as I understand your argument, you essentially want that language to be trumped by the fact that she was the parent of primary residence under the BARA standard. Now, why would a lawyer ever advise a client if the relocation language were essentially set aside to agree to the other party being the parent of primary residence, if the client was willing to spend half the time or close to half the time and have a true shared custody arrangement instead? You're creating a disincentive for parents to agree to give the other party that designation.
I appreciate the question. However, I think when you drill down into this language, in this particular case, you'll see that the restrictions were intrastate. And that's understandable because you could go from Sussex County to Cape May and that could be a problem. But there's no restrictions on her leaving out of state.
Neither party shall permanently relocate with the children from the state of New Jersey without the prior written consent of the other.
Yeah, and if the consent isn't given, it wasn't a no, you're stuck. What happens when 2 parties are stuck? They go to court.
They go to court.
That's what we do. That's what divorce lawyers do, and that's what we do. Did I answer the question, Judge?
No. What I was trying to get at is, if in fact Bowers creates a strong incentive or disincentive for a party to agree to give the other party in a settlement the designation of PPR, because that suddenly really dramatically changes the burdens that are imposed. Why is that a good thing?
2 answers, if I could. Since 2001, this court has not been inundated with that particular appeal. parties recognize when they're getting divorced, somebody's a PPR, somebody's a PAR. And most good matrimonial attorneys will say, if you think there's going to be a relocation issue, we want to make sure that that designation is correct. So it's there. When we talk to clients,
How about if one party knows that there's going to be a relocation issue, the other one doesn't? And
Then
the
we're
reporting
getting-
system being the PPR. Would
Then-
that be bad faith?
no, sir. Because you're getting into the subjective
The
intent.
fact that one party's aware of a fact that will change the location, locale where the parties and the children live, and the other one's not aware of that fact,
What I'm going to respectfully
that's not
say-
bad faith?
What I'm going to respectfully say is that you're now getting into the subjective intent at the second that they signed that. We cannot do that.
Doesn't Bowers
What?
say you're wrong?
No, sir.
Bowers says go back to court and first have a plenary hearing, go back to trial, have a plenary hearing on whether the agreement was entered into in good faith. Exactly what you said the court shouldn't have to determine by a plenary hearing. That's step one before they ever get to inimical to the interests of the children.
I'm going to respectfully
Go ahead.
disagree with Your Honor.
And by the way,
Bowers does
didn't
not say
O'Connor
a
do the
plenary
same
hearing
thing?
every time, sir.
No, no. Okay.
You have the floor.
Bowers said, in that case, go back to trial, conduct a plenary hearing, and determine whether the agreement was entered into in good faith. And if so, then go to step two, inimical to the best interest of the child. Doesn't Bowers say you're exactly wrong, that there needs to be a plenary hearing if there's been an allegation of bad faith? Isn't Justice Fernandez-Vina correct?
In the abstract, I will acquiesce and say yes.
But
in
that's
the
what Bowers
abstract.
says.
But I have to argue my client's position as we are here, because Gabrielle and Gianna have to go back to Utah. But in the abstract, if that's what we're answering,
not
I will
abstract.
say yes.
That's what Bowers says.
Oh, it does say that, sir.
Okay.
Yes,
I'm
I agree with you. I'm not
just
saying it
checking.
doesn't
I
say
thought maybe I
that.
misread.
But
By
what
the
I'm
way-
saying in this particular case,
O'Connor's an appellate division case. Wasn't there also a plenary hearing to determine whether, in fact, it was shared or primary, secondary, primary, alternate? Well, isn't that what O'Connor was too?
yes, but there's not a plenary hearing every time.
No.
That is true.
You're citing O'Connor for a proposition. And that proposition is that this is what O'Connor took into account to determine that it was a primary, secondary, custodial parent relationship. O'Connor did exactly what we're talking about here. They had a plenary hearing, determine exactly what the facts and circumstances are, and a trial judge applied equity, listened to all the facts, made a judgment, a subjective determination that in fact it was primary, secondary, not shared, not joint. Bowers was going to go back, and the judge was going to hear all the evidence and make a subjective determination, concluding that they did or didn't enter into the agreement in bad faith. Isn't that all we're talking about here? And you're saying that can't happen or shouldn't happen?
No,
I think every case. There may be stipulations, there
I'm
may
not
be agreements.
saying that, sir. What I'm saying the appellate division did was to change the Bowers law. If we're here to discuss Bowers, I'm all for Bowers. Please, understand that.
So you're okay with going back for a plenary hearing on good
If
faith?
the cases merit it. But this case does not. So I am arguing this case, sir.
You don't think
And
there's
what the
some
appellate division
some
did.
evidence of perhaps bad faith that a court could find in this case?
No, sir.
None
No matter-
whatsoever.
No, sir.
As a
No matter what.
As a matter of law,
Yes, sir.
on these facts, there should be a finding of no bad faith. is your-
Absolutely.
So you've
Because
come,
just look at the record, and I apologize for interrupting, but look at the record.
you've come forward with the proposition that you've stated several times that this analysis must be objective and cannot consider subjective thoughts. Can you point to authority that uses that language?
In where, sir? I apologize.
My question to you, you've argued to us that you can only consider the objective facts of record and cannot explore subjective intent. Can you point to authority for that proposition that uses that language? Not your interpretation of what cases must mean, but has that been said by a court?
My initial reaction would be Bowers. I know you don't want me to say that, but I cannot find that specific.
You're welcome to say it, but tell us where.
I don't believe the specific language is there, but when you start talking about fraud and that thin line, and it's the new standard that the appellate division
So let me
brought up,
read you
proving bad faith.
a sentence from Bowers that may shed some light on this. It's from page 119. It's talking about the burden on the non-custodial parent going forward to show evidence that the custodial parent is not acting in good faith. And I'm quoting. Excuse me. She might, for example, challenge the move as pretextual and show that the custodial parent's past actions reveal a desire to stymie her relationship with the child, thus bearing on good faith. What do you think that means?
It means exactly what it says, and I apologize, Joseph. I'm not being trite. I'm trying to say Bowers is good law. Bowers works. I am concerned now.
Bowers specifically says the custodial parent is using pretextual reasons to remove the child to another state. That will be indicative of lack of good faith.
I agree, sir. And I know you think this is inconsistent, but it is not. Bowers is good law. It should not be changed by the appellate division, and that's what the appellate division has tried to do. When you look at the statute that they're trying to bring up,
I'm sorry to interrupt you, but you're going on to a different aspect of this, and that's the standard. The question we have here is whether Bowers is authority for the proposition that you have been arguing, which is that only objective circumstances and facts can be considered in this with respect to good faith. Is someone physically in a state or not, and so forth. And you were asked by the Chief Justice for authority on that, and you cited Bowers. But I think you have to concede that Bowers does not stand for that proposition, because the very type of hearing that it was envisioning was going into the intent of the parties.
I appreciate that. And my answer is going to be this. What the appellate division has done, and make no mistakes, because the appellate division has modified Bowers. That is a clear modification of two standards that was never there before.
I understand that, but
I don't mind the good faith
do you see the distinction?
standard, and we can reach the good faith standard.
Yeah, we're talking about here the concept of a plenary hearing to determine good faith. And as to that, Bowers doesn't help you with the limitations you want to put on it. So
I am not saying specifically that you never, ever, ever look at subjective intent. But what I am saying is that what the appellate division did was mandate and create new standards that we should not have. Bowers is good law. That was the first thing I said. I appreciate Bowers, but I believe it is far more objective than what the appellate division did. So that's really what I'm saying.
So we'll interpret Bowers. Let's come to the question that you've posed. You said Bowers is good law, and Justice Timpone earlier pointed to some of the social science on which Bowers relies. At page 106, there are a number of studies that are mentioned. Is that still reliable support for Bowers? It's come under question in a number of quarters, and at least one court has backed away from it. Tell us why it's still good law.
Yes, sir. For several reasons. I know that my adversary has a couple of studies and a couple of positions, but if we're looking at this particular case, that is good law. And those are good studies. If we are going to, because a study comes up 1 year later, 6 months later, 7 months later, then this court, respectfully, becomes the legislature.
Well, let's pause on that, because the legislature has the statute itself doesn't include all that Bowers has. You agree that the statute itself simply says they shall not be removed out of its jurisdiction, etc., without the consent of both parents unless the court upon cause shown shall otherwise order. That's what the legislature provides us with. Would you agree that Bowers establishes a standard for that court determination that is beyond, not necessarily inconsistent, but is in more detail than the legislature's provided?
An interpretation, yes, ma'am.
Yes, and that was based in part on social science, on studies that at the time suggested that what was good for the custodial parent was in essence good for the child.
Yes, ma'am, that's exactly what it was. But when you look at this particular case, and you look at where we are, which is what I have to argue.
The studies are either correct in their opinions, or they've been outdated by other studies. But the fact that the facts in this case do not make the study any more credible or less credible. They're the facts in the case that you apply to the studies, not the other way around.
If this is thank you, sir.
You're welcome.
I appreciate that question. If this is a trial of one study versus another study, then I think we are all in trouble. What I am trying to articulate to this
No, we're not in
court-
trouble. What we should do is have a humble realization of the limitations of human knowledge, and that when the social science evidence conflicts with each other, we shouldn't be necessarily making hard and fast rules. And that's the reason why the best interest standard, which takes into consideration a whole spectrum of factors under multiple unique scenarios, give the family court judges the ability to craft fair judgments, equitable judgments in particular cases, without the judiciary putting its thumb on one piece of social science evidence that may be contradicted by another piece of social science evidence.
But, sir, isn't that the question that I was just asked? And isn't that the question the Chief Justice just asked? My position is we can come back here next week and have another debate regarding social science studies, or next month or next year, but we have to follow your decisions.
So let's focus on that. Take it outside of the Bowers case for a moment. Supposing the court has a decision that relies on social science evidence, and it sets forth a test and factors to be applied as a result of that social science. And then years pass and it is undisputed that that social science is no longer reliable. What is the court to do under those circumstances?
Under that particular circumstance,
Yes.
sir, that assumes that the studies that you are relying upon are the end-all be-all, that that's it, that that's what it's going to be. And what I'm trying to say to this court is that we could do that every week.
Can
I don't
you
believe
answer-
this is the time.
Can you answer the question that I posed?
With that hypothetical, what is the court supposed to do? I can answer it several ways. I'll find 42 studies against it.
No, you're arguing the hypothetical. I want to establish a basic principle, and you may or may not agree with it. But if it's undisputed that the studies the court relied upon are no longer reliable, should the court say, well, it's 7 weeks and we don't want to be doing this again and again, we're just going to look the other way? Or should the court revisit it?
Well, Your Honor, respectfully, obviously we can all argue extremes. And that's exactly what you're asking me to do. I can't say no to that position. You have to look at it and determine whether you're legislating or whether you are applying the law that the legislature creates.
Let me interject something. The legislature talks about custody. The legislature set no standard for a court's determination as to how custody is going to be determined. Look at that statute and tell me where in there it says anything about the standard to be applied by the court to whom the legislature looked to decide the ultimate issue of custody. And then I have another question. But tell me where in the statute does it say that? What's the standard? Not
Two answers
reasons.
if I could. First off, I knew that someone was going to get angry when I started.
I'm not
that-
angry.
He's not
that
angry.
You haven't seen me
level-
angry.
That
You
level
should
of
come here for the
discussion.
previous
You'll know when
argument.
he's angry.
You
And
should
I
have been
knew
here for the previous argument.
Someone would go, Paul, where are you going with that argument? You got to be
No.
crazy to tell
Where-
these 7 judges that they're now legislators, but
No,
these
no.
are all hypotheticals.
Where?
We're
No,
talking
no,
about.
no,
But
what-
if it's called for,
Stop. I'm asking you a
Now
question.
he's angry.
Stop. I'm asking you a question. Where in the statute that you have cited, which I have in front of me right now, does it tell us the standard courts are to use, rather than simply saying the courts decide the standard? Where does it say, where does the legislature tell us the standard to be used?
Are you looking at 922 or
Yes,
924?
922.
Okay, it's not there, sir. You know, I'm sorry, but you know the answer to that
Where
question.
is
It's not
it?
there.
Where is it? And
It's
quote,
not.
it's not anywhere.
No, it's in case law.
Okay. And we said case law. Now let me ask you question number 2. Is there any issue in a child custody matter, anything, that does not use a best interest of the child standard except under Bowers? Ever, anywhere else, in any child custody issue that does not use the best interest of the child standard?
It's only in Bowers, sir. It's only in the relocation.
The only time. And that Bowers was based upon studies at the time, not based upon the standards that were typically used by courts, because the legislature left it to the courts to determine. Right? Is that true? Is that a yes?
The answer of a yes would
Okay.
be yes.
So take that. Bowers says you cannot remove the child if it would cause harm to the child. Correct?
Correct.
So, is it possible that the move will not cause harm to the child, but yet will not be in the best interest of the child?
Anything's possible, sir. You know that.
Well,
Yes,
well,
it is possible.
and that is sort of an absurd result, wouldn't you say, under the statute, or at least under the prevailing notion of the best interest of the child that applies in so many different circumstances?
I don't think it's absurd. If it happens, it happens. I can't think of the factual scenario, but anything is possible.
But do you think that's what the legislature had in mind when it's talking about the interest of the child? It's not in the best interest of the child for the child to be moved to Utah, but it won't cause harm, so we'll let it go.
There's 2 positions. I am very concerned about the appellate division, number 1. And number 2, I do not believe that this court, now I am going to get yelled at, is a court that
By
makes
me.
decisions and waits for the law to catch up to it. I don't think that's this court. I think this court applies the law.
We revisit.
And then the law, and
things
that's what
change.
happens.
Look, so the Bowers standard was based on social science. And
Part of it, sir.
Yeah, and social science changes. It's changed in the area of eyewitness identification. And not too long ago, we actually revisited our rules and standards on eyewitness identification based upon changing social science. So why would we do it here? And it may be that the social science is just not demonstrative one way or the other. And therefore, we shouldn't be making hard and fast rules that's changing our general notion of best interest of the child. Go ahead.
If I may.
Yes.
1, it's going to create a plenary hearing in every single case. 2, I believe that would be a situation, every single case. 2, I believe that would be a situation of a court making a ruling and waiting for the law to catch up.
You've now said that twice. What does that mean?
What that means is, if you're creating a law that doesn't exist, then you're waiting for the law. Doing what's right, here's another way for me to put it.
Creating
Thank
what
you.
kind of law that doesn't exist?
Doing what's right and waiting for the courts, waiting for the laws to catch up. I don't think that's what the Supreme Court should do.
What? Well,
You're saying the legislature, if we do that, well, the legislature's entitled to, but they're going to weigh in and change the standard that we set after they said in the statute, you courts decide, you set the standard.
The standard has been set. What
By
I'm
who?
trying to say respectfully.
By who?
Respectfully.
By who?
By the court.
Oh, okay.
We're
I'm
not,
not saying
we're not
you
infallible.
can't.
We're not infallible.
Yes, you are, sir. You are.
Okay.
You are.
I
who
agree
you
with
are.
counsel. I agree with
I would
counsel.
never say that. I mean, you are infallible. But
Oh.
my position, and I'm sorry, Chief Justice, my position is really that the law is there. Apply it. Don't change it
the
or
law is
modify
what?
it.
What are you talking about? Bowers?
Yes, ma'am.
You're saying the law. So when you say that
The wheel's
waiting-
been invented. Let's not reinvent the wheel.
So one of the reasons you've said not to reinvent the wheel is it would create plenary hearings in these cases.
Yes, sir.
Why is that a bad thing when we're talking about a decision that would separate parent from child by thousands of miles? Why is it a bad thing as a proposition for a judge to conduct a hearing and make a determination, is this in the best interest of the child?
Wonderful question. I am a father of 3, and I every day have to go, boy, that was tough. I don't know if that's going to work.
Why don't you answer the Chief's
when they're
question?
far away.
Why is it a bad thing? Why don't you focus on what the Chief Justice asked you? Why is it a bad thing to have plenary hearings for something of such high stakes as an issue?
I'm trying to answer it, possibly not as quickly as you want, but I'll do my best, sir.
I just want you to focus on the question, not speed.
Because, well, there's a couple of reasons. There are times, sir, when it's not appropriate, when a decision can be made expeditiously so that children don't have to wait 4 years to move. People get job offers. People get married. People do many, many factual things that require an objective, expeditious method of removal. There are times when a plenary hearing is necessary. But to do a plenary hearing for everyone, I guess, as a lawyer, a matrimonial lawyer, I should say, that's a great idea, sir, because then I'll be trying every single thing, and every attorney will love me because I'm the one who created the plenary hearing standard.
First of all, you only have a plenary hearing when the parties have not reached agreement. That's number one. And number two, you have a plenary hearing when there are contested facts. That's when you have a plenary hearing. You need a fact finder to determine which side is right. And fact findings are very difficult when they're impossible when credibility determinations have to be made. You can't make credibility determinations from certifications. Agreed?
Agreed. But in this particular case, we don't have that. We do not have that at all. Please check the record. I know you have all.
You have a dispute between as to these two parties say something very different about their conversations with respect to your client's relationship at the time of their agreements. They have a factual dispute over who said what to who with respect to the timing and the seriousness of the potential relationship. Correct?
I agree.
Okay. So why isn't that a contested fact that requires a court to determine who's telling the truth, or maybe neither one are telling the truth?
When I was getting ready for this argument, don't yell at me, please, sir. When I was getting ready for the argument, that was a fact that I didn't really want to hit on, but thank you for hitting that one. It is a contested fact, and I understand it, but I don't believe it rises to the level of a plenary hearing.
Well, it is an example. It is an example of a situation where, and I'm just saying this hypothetically, if one or the other is telling an untruth with respect to what was said to one another, that may very well go straight to the heart of the issue of bad faith. So what's wrong with having courts who are experienced judges and know how to conduct a hearing, hear everybody out and to make a determination as to credibility? When we're talking about, you started out with an absolutely true statement, the two most important people in the world to this case are those twins. Okay, so why isn't their welfare worth the court holding a hearing?
Two things, if I could, and I apologize, justices, if I am confusing the hypothetical with my client's case, because I tend to answer based on my client's case. But to answer that question, there are times when you don't have to have a plenary hearing, and this is one of those times. If the law wants to change going forward, it changes going forward. But
Why is this not one of those times, sir? Why is this not one of those times?
Because I believe objectively it was clear. Judge Wright did the correct thing.
Let
the law perfectly. If the law is going to change, please let Gabrielle
Let me ask you this.
go to Utah.
Let me read you some stuff that I believe is undisputed. Prior to the finalization of the divorce in November 2013, Mrs. Bisbing began a long-distance relationship with Jack. She says that he was aware of the relationship and she was forthright all the time. He says he was not aware of it prior to the entry into the agreement. In July 2014, suddenly, without any prior mention of it, Mrs. Bisbing says that the girls are miserable at their school and Utah provides better educational opportunities. Nothing like that ever came before. Suddenly, she begins to curtail Mr. Bisbing's visiting activities and no longer allows the girls to stay overnight on Sundays and Wednesdays. Isn't that a disputed fact that the court should determine who is in fact being candid and who is not? I'm just reading some of the facts. There are more if you would like me to read more.
I agree. I'll address every single fact. If I may start with the first one, the relationship. Are we, as a court, going to go and say, if anyone alleges someone is in a relationship after a divorce, then that it requires a plenary hearing? That's very
Isn't that a
difficult.
credibility finding, sir? And how do you make credibility findings other than observing the demeanor of the witnesses, their ability to answer, their candor in answering, their reluctance to answer? Aren't they the factors that the court considers in determining the credibility of a witness?
Yes, but then
And
what
how do you
you're
do
going,
that from a piece of paper?
what you're going to do, sir, if I may, is you're then going to make every case question text messages, phone calls. We're going to have tolls to see who went through the Garden State Parkway toll. We can't go there. We can't go there to figure out the quality of a relationship. It's just far too subjective.
If it's a contested fact, we have to go there. We go there every day. Every family court case I was ever involved in went there. That's exactly what we do. That's why we have judges. That's why trial judges wear robes. It's exactly where we have to go.
I believe these facts, the objective nature of them, not just an allegation that there was a relationship, should suffice to raise to the level of plenary hearing.
Where in the record are those facts resolved in favor of the husband's position or the wife's position?
The
Where in
record, sir. I'll draw your attention to the judge's conclusion.
Okay, after reading certifications.
I have it.
After reading certifications.
And oral argument. Yes, sir.
Okay.
PA 29.
Our argument is not testimony.
I understand, sir, but there was some testimony given
By.
by Ms. Bisbing.
Okay.
She was put under oath, but it's right here. It says,
Do you know how many trial courts have been reversed when they make a factual determination without a plenary hearing?
a lot, sir. It's one of my easiest ways to get a hearing, is just
More
to
than
say
a
there's
lot.
a question of fact.
More than a lot.
I do it all the time.
Counsel, we're not going to try the hearing right now. I don't want to belabor too much time.
Judge Wright, sir, in the record, on or about PA 2726, said that there's no bad faith. I apologize. And talk about the relationship.
So we're approaching an hour at this point. We'll have you back for rebuttal unless there's something very, very briefly you'd like to add at this point.
If I get rebuttal, I will be quiet.
Yes, you're going to get rebuttal.
Thank you, sir.
Mr. McGoffin.
Thank you and good afternoon, Mr. Chief Justice, Associate Justices. It's my pleasure to be here. I'm speaking as amicus on behalf of the New Jersey State Bar Association. Our amicus position is very limited, and it's based upon the proposition that the appellate division had that they qualified this particular provision in the agreement as a non-relocation provision. We have the same concerns that some of the questions that have been raised here as to how the record has arrived before this court on motion practice and without a hearing. We believe that these issues in this case require some strict scrutiny by the court, similar to how the court handled Fozzie. The bar's concern is how is the direction going to be for practitioners to deal with enforcement of these relocation provisions and enforcement by the court as to these non-relocation provisions. So we've gone from the general principle that this is accepted as a non-relocation provision by the appellate division. The waiver issue is where we believe is a threshold issue that has to be dealt with on a trial court level, specifically under the facts of this case. 2 pro se litigants go to mediation. An attorney, who is the mediator, resolves the matter. So there's a lot of issues as to what information was provided to them as to this particular waiver. And it's interesting, in the appellate division, what they had indicated was it wasn't a total bar. This relocation language that they accepted as JAIME, and I used her first name just as the appellate division did, was giving away her right of that freedom to move. So they've accepted that as a statutory right, but also indicated that it wasn't a permanent bar. The the State Bar's position is not that we want to deter the rights of parties for their self-determination. It's a question of whether you need to know those rights before they are waived. As Fawzi indicated, the factors considered is the understanding the right of the judicial determination and knowing the waiver, significant time to consider the implications. Here, as the record reflects, the parties were both pro se, came out of mediation. They resolved their case in March. They were divorced in April. That's a very quick time frame, not quite a lot of time for deliberation. We also have concern that there's no specific waiver language in the particular agreement that says you are waiving your right to a judicial determination. As this court determined in Altalis versus U.S. Legal Services, that's a requirement, should be in there. Your specific waiver language that you are waiving the right to have a court make a determination. And again, that was dealing with arbitration, but also a statutory right. We believe that between Fawzi and Altalis, that this provides that kind of strict scrutiny that courts have to look at, especially in light of pro se litigants. I don't think that this is going to create the kind of floodgate that has been predicted in regards to a voir dire of parties when they're getting their divorce done. When there are attorneys handling the cases, those are the kind of questions that are being asked. Do you understand it? Do you fully agree with this? Do you have any questions today? Has your lawyer answered all of your questions? When you have pro se litigants, that's not the same. That creates some questions of concern for the bar. We believe that the court must make a finding that there is a clear, unmistakable waiver. How this all fits into the Shea analysis, Judge Millard's decision, is a decision for you we haven't really touched on. But the bar's position believes that if there is a clear or not a clear, unmistakable waiver, then you're back at Bowery's. How Shea fits into that, that's for your honors to decide, and the appellate division certainly waived in on that. And if there is a clear, mistakable waiver of that right, the question then is whether or not the waiver, there's a change in circumstances that has occurred that no longer makes that waiver in the best interest of the child, and then you continue with a best interest standard.
Do you? I'm sorry. Go ahead. Have you finished your opening statement? Obviously, your brief is limited to the question of the clarity of the waiver, right, and pro se issues that you raise. Does the State Bar have a position with respect to whether the Bauer standard, which obviously differs from the best interest standard in situations where there's a parent of primary residence, whether that should remain the standard?
In anticipation of that, I brought this to the podium,
Boy, am I predictable.
knowing the questions that have been asked. Yes, the State Bar Association has taken a position in regards to the Bowery standards, and that was based upon Justice Long speaking at some event at an annual meeting, thought that it might be time to review, and that is in fact what's codified and was attached to the respondent's brief.
Now, this situation isn't like an Adderley situation, because you have father, mother, and then the court always has a parent's portray obligation to ensure the best interests of the child. So that cannot be waived as a matter of public policy. Wouldn't you agree?
I would agree. Of course, the court always has that the obligation to look out for the best interests of the children.
And even the agreement that was signed in this case would not exclude changed circumstances.
Never. No, changed
circumstances.
circumstances.
So just so we're clear, even the most ironclad non-relocation agreement could not exclude an examination by the court of the best interests of the child.
A change in circumstances, best interest of the child, certainly. If there's a change in circumstances from the time of the original agreement that would justify a review of that particular provision, that's exactly the standard that we think the court should adopt.
Did you say, maybe I didn't hear it clearly, is it the bar's position that the Bowers standard should be revisited? In other words, the studies relied upon, the basis for Bowers needs to be revisited by this court?
Yes.
Okay.
Does the bar have a position about what the standard should be, or just that Bowers should be revisited?
It's best interest standard. As set forth in the legislation that was attached proposed legislation attached to the thing that was formulated by the State Bar.
Justice.
I think that answered my question.
Okay. Anything further?
Thank you.
Thank you.
Mr. Nunn.
Mr. Chief Justice, Justices, may it please the Court. The public policy of this state is to encourage and enforce settlements. It doesn't take a great leap of logic to understand why we have matrimonial cases that take 5 years to get resolved. And that's not through the fault of the court, but through the fault of motions after motions, reconsiderations of reconsiderations. It's a problem. Here we have two college-educated corporate executives who met with an attorney mediator. They agreed, as the initial custody determination, something a court would do, that the best interests of their children were served by a mutual, and that is a word that has not yet been discussed here, a mutual restriction on relocation. This is not a one-way provision. This is not a provision that I think may raise the ire, for example, of Justice Alvin based on his dissent in Quinn. Mom can only relocate if she never gets married. Well, of course that's unenforceable. That's against public policy. That's not what transpired here. These two people have family all within 25 to 30 miles. They believed it was in their children's best interests. Less than a year after they signed this agreement, Mom seeks to relocate to Utah, to a state in which there's a gentleman she had been dating prior to signing the agreement. And she now asks the trial court and now this court to absolve her of the terms of the agreement. What does that say about the enforceability of agreements, in your words? And I understand the argument that she's pro se, but the agreement contains other provisions, like Section 8.1 of the agreement, which talks about the fact that both parties realize they had a right to get counsel, that they should get counsel, that they understand the terms, whether or not they got counsel. There's a provision about the entire understanding. There were no other side agreements related to this agreement. And so it's the respondent's position that in this case, and I will address the final line of question that Justice Alvin had for my adversary regarding the court's parents' patriae authority, which I know very well, and I agree. I agree that the court absolutely has an obligation and a right to review any provision under its parents' patriae authority. But if the colloquy that went on today didn't focus on Bowers, which I'm glad that it did because I did intend to address it, what I had intended to focus on is that in Cooper and Holder, the Supreme Court's issues with relocation, it's essentially you're at that point in time, it was primarily mothers who were still the primary custodial parent. You're essentially tying someone to a state where dad could have relocated to any jurisdiction that he wanted. And that should be against public policy. You had in Cooper the notion based on Dr. Wallerstein's social science, which has been discussed a bit, not directly, but I think that's what the court is referring to, that what's good for mom or what's good for the custodial parent is good for the children. That was part of the tenets upon which Cooper was based. These parties in their MSA, DA 24, the parties hereby acknowledge that the children's quality of life and style of life are provided equally by husband and wife. It's very different than in Cooper, where the court said the realities of the situation after divorce compel the realization that the child's quality of life and style of life are provided by the custodial parent. That was the social science. These are two litigants who negotiated this agreement themselves, disagreeing with that notion from Cooper. That's an important distinction. So this case raises several questions. We have the question from the State Bar, which in essence is also the question that the appellant raises. Did the appellant waive her right to file an application? And I emphasize what the right actually is under NJSA 922. The right is not to relocate. It's to file an application to have a judge decide it. And there were several questions to my adversary about the court's role under 922. There can be no mistake. The legislature vested within this court the authority to decide the issue of relocation and whatever standard it is that amounts to good cause, which was in the statute. The answer to that is no. An officer of the court, I'm going to be candid and intellectually honest, neither party waived their right. It's not in the agreement. question is, did the appellant waive her right to relocate out of the state of New Jersey with the children? The answer is yes, she did. But so too did Mr. Bisbing tie himself to a particular radius and a particular geographic area of New Jersey. Raises another question. Is an anti-relocation provision against public policy? It could be. It certainly could be. He gave an example. Mom can only relocate if she never gets married again. Against public policy, I can't see any court enforcing that provision. It reminds one of the Giangiarusso, Judge Graves' trial court case, which His Honor Justice Albin cited to in Quinn dissent as being against public policy. It would be against public policy. So the question then is are anti-relocation provisions, as this has been coined, subject to a change in circumstances analysis? It's a very important point in this case, because if the standard is yes, they are subject to a change in circumstances, rhetorically, was there truly a change in circumstances from the time the agreement was signed if this relationship was predestined? Was there truly a change in circumstances? But more globally, because this is the Supreme Court, these provisions should be subject to review under this court's or any trial court's parents patriae authority when circumstances arise that would leave a court who has the jurisdiction to determine it's now inimical, it's now against the children's welfare, safety, health, best interests to remain in the state of New Jersey. Those are the types of circumstances where a court should absolutely go beyond the four corners of the agreement. And so my final point is that what would the standard be in those circumstances? And I submit to the court, and I will not belabor it, and my time is probably running out. Bowers can no longer be the standard. And I regret, I don't recall if it was Justice Albin or the Chief Justice who commented that it may be that the social science just doesn't prove it either way. There's no overwhelming support in either direction. But if that, in fact, is the case now, and we know that now, and I suggest that the multiple articles I provided, peer-reviewed journals, stand for the proposition that, if nothing else, Dr. Wallerstein's 1980 and 1996 articles, they have no more support today than they did at that time. And in fact, the weight of social science suggests every case needs to be handled on a case-by-case basis with the particular children.
To the extent that the proposition that what is good for the custodial parent is good for the child may apply in force in a particular case, which of the best interest factors would allow a court to consider those factors?
Well, so the beauty of, and Justice Long was mentioned, the beauty of Bowers and Justice Long's written opinion, there are factors in there. They're wonderful factors. The issue isn't the factors. The issue isn't the best interest standard and the factors that are already in 924. The issue is, like it or not, trial courts read this burden shifting, and I think that's what happened in this case, and the notion is it's not a high hurdle, and in fact there are cases that say that. Good faith, not inimical, not a really high hurdle, burdens then on the non-custodial parent. That's the problem. So I think some sort of amalgamation of, and frankly the state bars, and I don't say this to be glib, they supported a standard that has bipartisan support in the legislature.
And my specific question about that standard is because obviously we're not in a position to judge the science of it, but to the extent that in a given case, Dr. Wallerstein's proposition, principle that she states is correct as to a particular family, the best interest factors, or some of the best interest factors, would allow a court to take that into consideration, would it not?
Justice Patterson, absolutely, because in 9 out of 10 of these cases, you have psychological evaluations. There are psychologists, forensic psychologists involved who are assessing all of these things. Now, granted, you then get into the battle of experts, which leads to some of these backlogs. But it's, and I'm sorry I'm being a bit long-winded in response, the answer is absolutely.
Your point is that it shouldn't be considered as a legal presumption. It's a fact that should be evaluated and considered.
Chief Justice, absolutely correct.
So what should trigger, in a case like this where you have the relocation language in 1.9, what would be sufficient to trigger a hearing?
So I think about Bowers, not so much because there was family in Wisconsin for the custodial parent. I think about a special needs child, and if within, in the context of this case, a 20-mile radius, there was not a single school or program that would make it so that the special needs child later on in life could better cope or better maybe become emancipated or maybe not rely on so much help and government assistance. If one of the two parents in that case tried to lock the other one into the 20-mile radius, first of all, I probably wouldn't represent that person. They would lose in the trial court because the court would be reviewing and hearing positions that what you're telling me is within 20 miles or inside of the state of New Jersey, there's not a single program that's suitable for this child. Of course this court would say, okay, we're going to excise the non-relocation provision. But to allow someone to sign an agreement that says, I will not, neither party shall relocate.
Okay, neither party.
Neither party.
Okay. So tell me how the court would enforce this agreement if your client decided he had to move to Boston for a better paying job.
They couldn't. He couldn't.
He couldn't.
Without her consent. And I know it may seem like I'm just saying that because I represent Mr. Bisbing, Your Honor.
You think a court could say that you're imprisoned in New Jersey and you cannot move to Boston to further your career? You think a court would have that power, and that wouldn't somehow be maybe violative of his right to travel?
That would be a privileges and immunities, potentially a right to travel, a fundamental
I mean,
right to travel.
it's one thing for a person to say I have a right to travel and take my child along with me. It's another thing when a person is moving on his or her own. Wouldn't you agree?
I do agree, Your Honor. And in this case, it's a bit nuanced, and here's why it's nuanced. Rarely do you have two parents agree in a non-50-50 shared custodial arrangement that the parties acknowledge the children's quality of life and lifestyle are provided equally by husband and wife, meaning the following, and Justice Tampone hit on this. This is a dad, he was going post-separation and post-divorce to mom's house while she was still working to get the kids ready for school so that she could commute to the city. And so I'm not arguing this amounts to O'Connor, but what I am saying in response to Your Honor's question, a change of custody analysis would have to be adopted in the circumstances where someone, the non-custodial parent, okay? Because what we're saying is the parties decided it's in the best interest for them to live close to each other. And if now dad is proposing to move to Boston to take a job, maybe that's inimical to the children. Maybe there's something in particular about these children. And under those circumstances, Your Honor, I think a court could say, we're going to hold this custody arrangement that you agreed to as being in the children's best interest.
And you think that a court can say to the non-custodial parent, you are not permitted to remove yourself from the state of New Jersey. This is where you're bound.
If a psychologist in a plenary hearing said, these children require the 3 to 4 day interaction, the overnight parenting time.
Do you know of any case
I do not, Your Honor.
that has held
No.
what you're proposing right now?
I do not, Your Honor. I also have never seen an agreement where both parties restricted themselves due to the best interests of the children. But, of course, the court can review the provision. The court always can.
Do you have any problem with the Appellate Division's substantial unanticipated change of circumstance?
I think it's just the same way as saying a change in circumstances, because, I mean, sort of implicitly, if circumstances change, if you were aware of them, signed an agreement saying, I'm not going to do X.
No, this is unanticipated, so that she's not aware of them. That's what the Appellate Division is saying. The Appellate Division says that Mrs. Bisbing cannot get out of this agreement if she was aware at the time of the agreement that she was going to be moving to Utah. But the Appellate Division says if she wasn't and this was completely unanticipated, then she could at least make this motion and argue.
Under Bowers.
Yes.
That's the problem I have with it.
Okay, so let's say forget about Bowers. It's under a best interest standard.
My position is in this case, related to these facts and disagreement with what the parties believed about each other's roles in their children's lives, the court should enforce the provision if there hasn't been a substantial change in circumstances from the time this agreement was signed that neither party will relocate.
Do you agree that there is a potential for the word unanticipated raises some proof problems? I mean, obviously Lepus talks about in very obviously different contexts changes in circumstances, but as far as I know, and you obviously know this law much better than I do,
I don't know about that.
that there's no requirement that when you come in on a change in circumstance in a LEPIS application that you prove you never saw it coming, in essence.
Correct, under LEPIS, but I do think with respect to a custody provision that a litigant is now seeking to, and I'm sorry, this is a bit colloquial, get out from underneath. If it's just a change in circumstances analysis, without looking into the good or bad faith, maybe the answer is it's a 451 application that there was a fraud, which was an argument that I did make at the appellate division. Maybe it shouldn't be that it's a substantial unanticipated. But I kind of think built into changes in circumstances are if you know something's coming down the road and you agree not to do that something, how can you later on, at a later point in time...
That was going to be my question to you. Aren't change circumstances generally unanticipated?
That's what I'm trying to say, if I'm not being clear.
Does it matter?
But it wouldn't have like a reduction in somebody's income. You would never get into, was that a surprise or what? It just happened. You wouldn't be...
I don't think that in an income analysis where one party agrees to pay X, but he or she knows they're going to be, taking a job that no longer pays a salary, they get stock options. If the person went into that scenario and signed an agreement, I'm only going to pay alimony based on salary and I exclude stock options, did the person have knowledge of it? Yeah, they had knowledge of it, and lo and behold, they take a job where it's just deferred compensation. I don't think that litigant would be permitted to come into court and say, oh, there's been a change in circumstances, I can't pay alimony.
I think the anticipated language there was really tied into the appellate divisions trying to anchor the term good faith in some sort of workable standard. And it seems to me that the appellate division was saying that if you really anticipated the change, you wouldn't be acting in good faith.
I concur.
Is there really a difference between unanticipated and maybe anticipated change in circumstances? Isn't the outcome still the same? It's what's in the best interest of the child, stay or go?
In custody cases, yes.
Okay, so
Yeah,
for our purposes, does it matter?
I don't think it matters. I do not think it matters in this case where there are issues involving children, because ultimately you're looking, and courts are looking at best interests. But there is a component to this case of Shea, which is a trial court opinion, and now there's appellate precedent, and the peculiar nature of this case is we not only have that element, we had the agreement element. So if this non-relocation provision didn't exist, I think the argument you're hearing is Shea and BISBING, to the extent that it allows a court to review an agreement followed by a relocation application and apply best interest if there was some sort of less than open behavior or open information. I think in that regard, this court should affirm the appellate division. I think Shea and BISBING in that regard is good law.
Anything you'd like to add?
I have nothing else, Your Honors.
Thank you. Mr. Townsend, rebuttal? You'll have a full 5 minutes, but we're limiting the argument to 5.
I'm going to do 5 minutes. First off, I want to thank the justices for your extreme patience. I in no way intended to upset anyone. I was just passionately regarding Gianna and Gabriella. I'm going to draw Your Honor's attention to PA 29, where Judge Wright stated, that's his transcript, there have been in the course of human affairs relationships that have moved from meeting someone to marrying them very quickly, period. Whether it's 5 months or 5 years, that is not prima facie indication of bad faith. So, that's what I want to leave you with, if I may, Justices. Gianna and Gabriella were in Utah for a year. They're stepbrothers, their stepfather. That's where they should be. If on a going forward basis, the court believes that the law should be changed, I understand. But in this particular factual circumstances, please apply Bowers. Thank you.
Thank you, counsel. We'll take the matter under advisement.